behalf of the appellant, Mr. Antwon Wiley, I'd like to reserve 4 minutes of my time for rebuttal. Mr. Wiley has raised 3 issues on appeal. 2 of them are sufficiency of the evidence, and then the third is a merger issue. Unless there are specific questions about the sufficiency related to identifying Mr. Wiley as the robber, I will leave that to the briefs and spend my time today on the other sufficiency issue regarding the presence of a deadly weapon and the merger issue. But I'll start with the deadly weapon issue. In cases like this where there's no direct evidence of a deadly weapon being present, there is a 2-part test for determining sufficiency of the evidence to support an aggravated robbery conviction. The first prong is some sort of furtive behavior indicating that there may be a weapon present. And here, in this case, that is when the robber enters the store, he's holding his hand kind of awkwardly around his waistband on his left side. The second prong is there has to be some sort of a threat made by the robber, it can be verbal or nonverbal, that supports a reasonable inference by the victim that the robber does in fact have a deadly weapon. And that's where the issue is in this case. There's no testimony in this case, no evidence presented that the robber ever made a statement that would constitute a threat to Ms. Cheney. Her testimony is the only source we have for any statements the robber made. And those statements are, when he enters the store, he tells her to go to the register and input the code. He tells her to give him all the money, including the small bills. He tells her to lift up the money tray to show him that there's nothing underneath. And then as he's leaving, he tells her, don't call the police. None of those constitute a threat. Under any of the case law, a threat in these kinds of cases is always something like, do it or else I'm going to hurt you, shoot you, etc. There has to be some sort of statement to that effect, and we don't have that here. There's one case in particular, State v. Hale, that allows a non-verbal threat to satisfy the second prong. And what happened there was the robber made a demand of a cashier to give him the money. The cashier did not immediately understand the robber and so didn't comply. And the robber in Hale, in response to that non-compliance, shakes his head and pats his pocket. And the shaking the head and the patting the pocket is what that court held was sufficient threat to uphold an aggravated robbery conviction. Here, we don't even have something rising to that level. The robber very quickly after the encounter removes his hand from his waistband area, and he doesn't return it there. He never makes any gestures. There's nothing that could constitute a threat that would support Mr. Wiley's aggravated robbery conviction.
So the victim, she testified, and there was also security camera?
Yes.
That showed whatever movements he made, so the jury saw all that.
The jury saw everything that happened. There is nothing in the video beyond what satisfies the first prong of the test, which is holding his hand awkwardly around the waistband. There's nothing beyond that that could be construed as a threat to support.
Okay, so what you just stated, place the Hale case into what you say is the 2-part analysis. Mm-hmm. Tell me the threat part of that.
So the 2 prongs in Hale. The first prong is the robber's pocket in that case is very clearly heavily weighted. Mm-hmm. That's what the proof showed. And then the threat prong is after the cashier fails to comply with the robber's demands, he shakes his head and pats his pocket. And that's the threat prong. Just one other point on the sufficiency issue. There is a logical issue with allowing an aggravated robbery conviction in this case, and that's that in the state's argument, everything that it points to support Ms. Cheney's, the cashier who was robbed, Ms. Cheney's inference that the robber had a deadly weapon, everything the state points to are just facts of an ordinary robbery. It's that he enters the store with his face concealed, he tells her to give him the money, all of that. That is all stuff that could happen in any robbery. The point of this 2-pronged test is to differentiate between ordinary robbery and aggravated robbery. And so there has to be a threat referencing something about the deadly weapon or supporting the inference, and we don't have that here.
Does the video show a handle?
There is something of a dispute between the parties. Our contention is that the video is too grainy to actually tell if there is anything in the waistband at all. Ms. Cheney explicitly testifies that she did not see if there was a handle. And so the only thing we really have to go off of is the video, and our contention is it is too inconclusive to actually conclude that.
Do you think that, based on the video and based on the testimony, she thought there was something there? The witness, the victim thought that he had some object in his waistband.
She says that she assumed that the robber had a weapon because of the way that he was awkwardly holding his hand. The issue is that's not enough. The robber has to do something additionally to support that assumption by the victim. If there are no further questions on that issue, I will move to the merger issue. Mr. Wiley was convicted of both aggravated robbery and theft arising out of this incident. Tennessee law is clear that theft offenses are defined based on the number of takings rather than the number of victims. There was only a single thing that was taken, $247 belonging to Dollar General from the cash register. And so only a single theft conviction could arise from this incident. That comes primarily from State v. Franklin, but it's supported by other cases as well. The state has argued that there were multiple victims in this case, which again is not how we define theft offenses, but there's also an issue with arguing that there were two victims here because nothing of Ms. Cheney's was taken. These are both theft offenses that Mr. Wiley was convicted of. And so it's about what was taken from the people. Only Dollar General had items that were taken from them, or an item, the $247. The fact that Ms. Cheney felt fear, that the testimony is that she was scared for her life, that fact is doubtlessly reprehensible, but it's not enough to support separate convictions for theft offenses. If the state wanted to punish the fear that Ms. Cheney felt specifically, it should have charged assault, and it didn't do that in this case. And so we would ask that this court merge Mr. Wiley's theft conviction with his aggravated robbery conviction.
Now, the state's arguing that that's waived because there was never anything raised on it in the lower court.
Right.
What is your argument about a waiver? And there was no request for plain error.
Well, so first of all, merger issues like this are frequently considered sua sponte by this court. They're kind of treated more as ministerial matters to just be corrected on the back end. We have argued the plain error factors in our brief out of an abundance of caution. Not being convicted of multiple theft offenses is clearly something that Mr. Wiley has a substantial right to. And so I'll just rest on the brief for the details of the plain error argument. It's really should be a ministerial issue to get corrected on the back end. If there are no further questions, I'll yield the remainder of my time. Thank you.
All right, thank you. General, let's see.
May it please the court, Ryan Davis on behalf of the state. This court should affirm the trial court, number one, because the evidence is sufficient to sustain the defendant's conviction for aggravated robbery, and number two, because the trial court did not plainly err in entering separate convictions for the defendant's distinct crimes. Like the defendant just now, I will rely on my brief for the identity argument, unless this court has questions. And so I'll give a brief factual overview of the situation leading to the aggravated robbery. So what we have here was the defendant worked at a Black & Decker factory across the street from the Dollar General. He left on his lunch break, goes to the Dollar General, and he buys some food items. He exits the store, and then he comes back to the Dollar General 13-ish minutes later, and he is dressed differently. He has a jacket on with a hood, and a clown mask, and sweatpants. And he enters the store through the front door. The store is cleared out at this point. He places his hand on some type of handle on his waistline, and he walks over to Miss Cheney, who's stocking shelves. The defendant then says, "Go to the register, give me the money." Grace complies. She gives her the money. He says, "Don't call the police," and he leaves. And so taking the common threads approach that this court generally uses for concealed handgun cases, number one, we have evidence of a concealed object. Grace testified that she thought that the defendant was placing his hand on a handle on his waistline. The video confirms that. There's a dispute on appeal about how grainy the video footage is. We don't think it's grainy really at all. It's clear enough for me, and I think it was clear enough for the jury. Plus Grace's testimony. So secondly, as far as the threat, the defendant entered a Dollar General wearing a mask, placing a hand on his waistline and demanding money. That's an implied threat. And so we think any rational jury could have easily viewed the videos and the testimony and concluded that defendant had some article that reasonably led Grace to fear for her life. And so we think that common threads, approach, that two-pronged test is satisfied.
Well, she stated she thought he had something, right?
Yes, she stated that, that she thought it was a weapon. I think she might have testified that she thought it was a gun. And she testified that his hand was going towards his waistline, or his pocket, or his waist, not fully in his pocket, not fully out, but like a handle of some sort. And so her testimony, that's enough. And then we have the video confirming it.
Was it clear from the record, how long she saw him grabbing at his waistband? You stated she was stocking shelves. Was he grabbing it the whole time, holding up his pants to walk, or was it clear that she saw that and immediately perceived a threat?
I think it was a relatively brief. Her perception was relatively brief, but she said that when he entered the store, he had the mask on, and she saw the hand. And so it was the entire encounter was relatively brief. But I think that her testimony was that she knew it was a threat. She knew that her life was no longer in her hands at that point. And so that's enough for aggravated robbery. And unless this court has questions, I'm going to turn to the merger issue now. So first of all, on the standard of review, we're on plain error. This wasn't raised below. There wasn't a contemporaneous objection. It wasn't in the motion for new trial. In our brief, we point out several places where this issue could have been brought up, and it was never raised. So we're on plain error. And it's our position that there wasn't a breach of a clear and unequivocal rule of law here. This was a multiple description claim. And so in those instances, we go down the Blockberger framework. And as an initial matter, the legislature hasn't precluded multiple punishments. Theft and aggravated robbery, or theft and robbery, are two different statutes in two different chapters of the code.
But isn't aggravated robbery aggravated theft? Theft is a lesser. I mean, if you
Yes.
go down the line, it's a lesser included. So isn't aggravated robbery a aggravated theft, basically?
Yeah, so what takes theft to robbery and then robbery to aggravated robbery, you get fear and then you have a deadly weapon. And so theft is a lesser included, and we completely acknowledge that. So in State v. Daring, a 2019 case, this court surveyed the robbery and theft statutes and said that there was no clear legislative intent to preclude multiple punishments on that initial threshold prong. And so that combined with the offenses being in different chapters of the code, one is a personal offense, one is a property offense, we get past that threshold prong. Then we get into Blockberger's step one, which is, same act or transaction, or if there are multiple victims. So here, we have multiple victims.
Well, I guess you only have multiple victims from the standpoint that I guess the corporation is one, who, the Dollar General, whatever, is that's their money technically. And the clerk is, I guess, theoretically in possession because they work there. It's not her money.
No.
It's the company's money, and the company was, I guess, Dollar General was victim one in the indictment?
I think count one was the aggravated robbery and Grace was the victim.
Theft of what, Grace was a victim?
Yes, so count one, aggravated robbery, right, so we aggravated robbery count one, and Grace Cheney was the individual put in
fear.
In fear.
Okay. And then count two is the theft from her?
From Dollar General.
From Dollar General, okay. Okay.
And so, our position is that there are two victims, and, Grace felt the fear, and then Dollar General lost its money. And when there are two victims, there can't be a double jeopardy violation. And so we think it's as simple as that. And because we're on plain air, the defendant needs to point to a clear and unequivocal rule of law that has been breached. And so even if the court disagrees with our analysis on this point, the defendant hasn't cited a post-Watkins case that says we lose. Pre-Watkins, you had State v. Hayes, which was from 1999. That relied on the old Denton framework, and it's bad law. Where is the post-Watkins Hayes? I haven't seen it in my research. I don't think the defendant has cited it. And because we're on plain air, he can't get relief in this case because he hasn't pointed to something that establishes this clear and unequivocal rule of law. So, pending any further questions, we ask that you affirm. Thank you.
All right, thank you. All right, counsel, your rebuttal?
Just briefly, Your Honors, just for clarification of Ms. Cheney's testimony on the deadly weapon issue, her testimony, it comes up several times whether there was a weapon or not. Nowhere in her testimony does she say, I saw a handle. She says, I assumed there was a handle. She says, I deliberately didn't look at his waistband to see if there was a handle because that would make it more real. And so her testimony is really inconclusive on the point of whether there's a deadly weapon, whether there's a handle in the robber's waistband or not. And then once again, I'll just point out that on the threat prong, all of the evidence that the state points to as evidence of a threat is just ordinary robbery facts. Nothing about it alludes to a deadly weapon or supports Ms. Cheney's inference. And then lastly, on the merger issue, the clear and unequivocal rule of law is State v. Franklin, which is a pre-Watkins case, but it's still good law. It hasn't been overruled. It still stands for the proposition that theft offenses in Tennessee are defined by the number of takings, not the number of victims, which was not changed by Watkins. So if there are no further questions.
All right, thank you.
Thank you.
All right, thank you for your arguments. We'll take this under advisement, and we'll be in recess until after lunch for the afternoon docket.